when clearly it is very well known in the law that an officer cannot have a disability that causes him not to be able to, you know, it can make him have issues in the law. So that's why it is well known that officers are not allowed to have any disability that could affect them or like affect their job or their duty.
So, are
All right.
you, just to summarize, to make sure that I'm understanding you correctly, what you're stating is that a peace officer or law enforcement officer has to go through training, physical training, and in order to fulfill their functions, they have to be physically and mentally able to carry out their
Yes.
duties. Is that what you're saying?
Yes.
Okay, I understand. Proceed.
And I believe that the officer should not only have to pay a fine for, being biased and not upholding the law in the correct way, but he should also get his training revoked and he has to get some retraining done before he can become an officer again.
How do you describe or how do you rationalize when you use the word biased? What actions on his end?
So if I link that back to evidence number one, sorry, Your Honor. Yep, go ahead. Your Honor, you're correct. So exactly, if I'm linking back to evidence number one, it clearly shows that Mr. Daniels states, I would have given you less time, but you gave me a hard time.
So
don't mark my word to word, but it's something to do
okay.
with.
Okay.
Yeah.
I understand. So what you claim is that the officer took it upon himself to not only apply the law, but didn't apply it according to the penal codes, rather deciding a imprisonment term all on his own and managed to moderate the amount of time that was assigned to the defendant.
No, what I meant is that also that he increased the time just because of personal emotions or personal bias towards the client.
Okay, and what was that individual charged with?
Not 100% sure about that, sir, but I believe he was charged with. Let me remember.
And is there actual evidence in your footage that substantiates the claim? Is there any evidence whatsoever, other than the words that were spoken? Can you evidence that officer, in fact, actually sent the individual off to an imprisonment term longer than the charge that was applied?
Well, that's some information I probably could not get a hold of, but what I'm trying to say, Your Honor, is that the statement of putting someone in jail for longer shouldn't be like. So my whole argument here is that a cop not only uses disability spot when he's clearly able, and if he does have a disability, he shouldn't be allowed as an officer that needs to uphold the law. This clearly brings apart the second part where he shows that he lets his emotional bias come in front of the law. Right? He clearly states that he's going to increase the time because we gave him a hard time. Even if it's a statement, all right, it's something an officer should not do, and it's against their conduct.
Yes, I understand what you're saying. Okay, I understand your claim now. What's your name, defense counsel, by the way?
It's gonna be Jake.
Jake.
Mr. Wolf, though.
What's your last name?
Wolf. Jake Wolf.
Okay, Mr. Wolf. You have the floor next for a rebuttal on those statements and the admitted evidences, both Exhibit A and Exhibit B. Go ahead.
All right. All right. So, just because the person I'm defending says that he was gonna put him in for more long time, although he was giving him a hard time, which is technically resisting arrest, because he was.
Objection, opinion.
Okay.
Hold on. Repeat
Your Honor.
the statement. Repeat the statement again. You said
he was technically resisting arrest.
who was resisting arrest?
The person who was being jailed.
Objection, opinion.
Okay,
He was never resisting.
just a second, just a second. Do you have any evidence to substantiate that he was resisting?
The officer has even said
And
that he
a
was
hearsay
giving me a hard
is
time.
not, no. Do you have any evidence to substantiate the claim that you just made?
No.
You don't.
Your Honor.
So it is hearsay, and the objection is sustained. You may.
Your Honor.
Yes.
I also would like to state he believes that when I meant give him a hard time, I don't mean he was resisting. I meant that because he requested legal counsel and wanted to sue, that's what he meant by a hard time.
Oh, I thought that meant something completely different. My fault. Well,
Carry on.
okay. Although my client might have parked in a disabled spot, that also could have been because he had a suspect, and I don't think at the area where he was arresting the suspect there was a suspect parking it lot.
Objection, opinion. He said, I think.
Sustained.
Mm-hmm. So
Mr. Wolf, please refrain from hearsay. If you don't have factual evidence to substantiate your claims, they will hold no validity.
And Your Honor, may I state something for the court?
Yes. Well,
It was such an
Is
emergency.
it an objection or?
It's just a statement.
Okay,
I'll
then-
talk
then
about it in
no.
my second argument.
Then,
All right, okay.
then no, it's his turn to finish. You'll have your time as well. Don't worry.
right. So my client, as he said he should do a retraining. After
Objection, hearsay.
Huh?
Repeat your claim. Who said he should do his training?
He should redo his training, I said.
Who said?
Him right here.
Right.
Oh.
But
Person.
that was an argument that he made that you don't need to necessarily recount upon. Rather, your focus should be on building a positive defense for whoever you're representing. Don't worry about who says what, because if it's an opinion, if that's what they think should happen, doesn't matter. And in the end, who decides that will be the court. So you shouldn't focus on that, but rather to be able to sustain the reason why you believe the officer that you're defending did everything as he should have. That should be your main focus.
Yes, Your Honor.
Go ahead and proceed. Or do you rest at this time?
1 second, please.
Sure.
So I currently have no ideas in my mind why he would.
Mhm.
So
What department is your client in?
I believe
You believe or you know?
I believe he is in
Oh boy.
the FGNA department. The FGNA. I don't know the full name for it, so that's the department he's in.
Counsel, do you know what department that is?
Oh, it's gonna be the Federal Gang and Narcotics Agency.
Okay.
That
Thank
the
you.
agency he's a part of.
What rank does he hold in that department or agency? Do you know that? Because that's going to determine a lot.
Okay, so depending on his going off his call sign,
Mhm.
he seems to be a special agent.
Okay.
I don't know for exact, but basing off his call sign,
Hmm?
I think he's a senior,
Okay,
special agent.
thank you. All right, that's fair enough. Do you have any other points that you'd like to add?
One second, please. All good.
Okay,
I'm done.
thank you. All right, plaintiff.
Your Honor, this is an obvious case, right? It's an obvious scenario. Everyone's seen this a thousand scenarios and like seen this scenario a thousand times, right? An officer, you know, starts growing a bit older, getting a bit slower, um, it's when people start retiring, and it's obvious through the evidence shown that, Your Honor, this officer isn't a victim. I must say, it's a lifestyle he chose, and clearly showed through his actions through the law that he's not capable of upholding the law.
He's not
All right.
capable of upholding the law
Of
just based on that incident or in general as an opinion.
No. In that incident, it is clear because he lets again his personal bias comes in the way. Just because someone gives you a hard time does not mean you increase, you know, their time or their sentence. That's not how the law works. All right. Especially because my client was a first timer. All crimes or all charges should be dropped to the minimum. And Your Honor, he clearly does not show that he care about that. He clearly shows that depending on his mood, he can choose how long someone could go for jail.
All right.
And and that's just all backed up from the fact that he doesn't care that he's parked in a disability spot. He doesn't care if he's taking up a spot for someone that actually needs it.
Was he on duty at the time?
He was on duty, but his emergency lights were not on.
Okay.
And if he was actually needing to park there like an emergency, he would have his lights and sirens on.
Sure.
I rest my case, Your Honor.
Thank you. All right. Defense, is there anything that you'd like to rebuttal or anything that you'd like to clarify or anything that you'd like to add further? Okay, I'll take that as a no then.
Yeah, there's nothing really I could say here.
All right, okay. So let me ask the following. Now that we've heard argument, counsel for the plaintiff, I'd like to hear your recommendations based on what you've gathered. What is it that you are suggesting the court to
right.
implement or carry out?
I believe, as a result of this case, I believe that my client deserves 20K in legal payments, another 30K in false imprisonment.
The
And also
20,
request-
the 20,000, the initial 20,000 sum would be justified again through why?
Paying for legal.
Pay. I'm sorry. Come again?
Paying for legal support.
Paying for legal support. So you mean attorney fees and court
Mhm.
fees? Okay.
Mm-hmm.
Okay. And the 30,000 for false imprisonment.
For false imprisonment.
Okay. All right.
And I also believe that the officer should either retire or forcibly be retired, okay? And or have to do their retraining.
Okay. Do you know the age of that officer?
Unsure, sir?
You don't know his age, right?
Nope, Your Honor.
Okay. All right. All right. Thank you for providing your statements and oral argument. This is actually quite frankly, a very simple and straightforward case. Officer Daniel, I don't know how long since that light was never shed onto the court. A lot of details have not been shed onto the court other than very basic preliminary details. However, through the evidence that we do have and that is admissible, we can witness what can be classified under the law as improper behavior, verbal behavior, but also actions that were fulfilled by the officer that are not within the conformity of the penal codes. I do believe that the actions that he did take, in fact, resemble very closely everything that our system stands against, which is dictatorship, which is oppression, and that is not what legal enforcement officers or law enforcement officials take a sworn oath to do, but rather the opposite, which is to know the limits and constraints of their role. You cannot be the judge, the jury, and the executioner all within the same role. That's tyrannical. I don't know how long he's been doing this. I don't know how many victims he has created, but I do know that if an individual's actions correlate to what is claimed and alleged here today, it leads one, but not exactly but one outcome, which is the following. The court finds that the officer, in fact, broke the law while on duty, parking in a disabled space. Being a law enforcement officer does not give you the authority to violate traffic laws or traffic signs. Therefore, I do find, beyond a reasonable doubt, that he is in a violation of civil statutes when it comes to the transportation code. And as evidenced, the court will agree partially with the recommended sentencing. The court will grant 10,000 for court attorney fees. And the court will grant 20,000 additionally, totaling 30,000 to be paid immediately to the plaintiff. And lastly, I do find, and the court does find, that empowering, allowing, or turning a blind eye to such behavior can put the general welfare of the public at risk. The behavior has to be modified, and I do agree that retraining is necessary at this time. If ever the incident was to reoccur and become a repeated occurrence, I do then would believe, but that would be up to whoever presides over that matter in the future to make such determinations. Closing statements I will waive. There's no need for them. And this particular matter is set as closed. The court will announce verdict on that court case publicly within the few minutes to follow. Thank you both, gentlemen.
Thank you, Your Honor.
Thank you.